bad circumstances or from others. So how you protect your loved ones or your beneficiaries from bad stuff that might happen to them in the future. But before we jump into that sort of stuff, I'm attorney Peter Harbach from Hooper Law Office. I'm one of the partners. Our office, we do nothing but estate planning and elder law. So planning people's estates, doing wills and trusts and things like that. We're doing long-term care planning. And, one of the topics that comes up quite a bit in the conversations that we have with our clients is, hey, I have concerns about my loved one. Maybe not because they're irresponsible, but because they're in a higher liability profession, or they might have different liabilities that come up in the future. And I want to make sure that my estate, or the portion of my estate that goes to my loved one, has as much protection as possible from those sort of bad circumstances, maybe gobbling up their inheritance. So that's going to be the core stuff that we're talking about today. So welcome. Appreciate everybody spending their time with us this afternoon. It's a nice day, so I can tell you're pretty interested in this topic, because otherwise you'd be outside enjoying the weather. So again, I'm attorney Peter Harbach. So today's topic, like I was just saying, it's how to protect your loved ones from others when they're beneficiaries of your estate. So a lot of focus on estate planning has to do with the individual circumstances of your beneficiaries. In a couple of weeks, our topic for our Wednesday webinar is going to be protecting people from themselves. And we're going to be running through, behavioral issues or other things where you might have concerns with people just having total access and the ability to use money however they want. But today's topic is, okay, we're not worried about the beneficiary themselves and their ability to maybe handle an inheritance. We're not worried that they're going to go out and spend it on drugs, or that they're not old enough to be, or mature enough to be good stewards of their inheritance, where we're trying to sever their control. But instead, today's topic is about, okay, maybe I have the world's most responsible child, but bad things can still happen to people. And are there measures that we can take that make good sense to make sure that the inheritance that goes to somebody goes to benefit them, meaning that it stays within their control. It isn't taken by bad circumstances that might not even be of their own making. So what kind of thing does that look like? I would say that maybe the most common concern that I ever hear is, hey, I love my son or daughter, but boy, they didn't marry well. I don't care much for my daughter or my son, or my daughter-in-law or my son-in-law. Maybe they don't know how to spend money appropriately, or maybe there's just some other issues where you'd be concerned that, hey, if I leave my child a bunch of money and they later get divorced, I want to do anything that I can to keep that divorcing spouse from being able to get at money that I spent my whole life earning to take care of my kids. And like I said, that's probably the most common concern that I hear out of individuals. And so there are ways to make sure that an inheritance that goes to your child remains individual property of just that child, meaning it doesn't become marital property. Not all property that gets inherited by somebody who's married just naturally becomes marital property and is subject to division in a divorce. And there's provisions you can put in your estate plan that can help ensure that, yep, this is just the assets of my child. They aren't for the benefit of their spouse. And so if they were to get divorced later, there's not a concern that that inheritance is divisible and goes over to that person that maybe you don't have a great relationship with, or at the very least, certainly you don't want the money going to them that you spent your life earning. Another big concern that people express is, hey, my child is very successful. They own their own business, or they're a doctor or an attorney or some kind of, higher liability profession. And, they're earning good money and they're working hard and they're very responsible and they understand the value of a dollar. But certainly, business owners or those types of professionals have a greater amount of liability in their lives due to the nature of their work than, the average person who's, working a clerking job. Again, what you can do in passing assets to somebody who's very responsible, but might get sued because they own a business and the floor waxer got a little too aggressive and somebody slipped and fell in their business and now they're on the hook for a lawsuit. Or doctors and lawyers, that's pretty evident that they can get sued for malpractice, and some claims are legitimate, some claims are a little egregious. And so those types of professionals, they often are really excited about the idea that, hey, if my inheritance from my folks in passing to me, if I'm able to invest it how I want and spend it for my own needs, but we're able to say, hey, this isn't on the table during a lawsuit because of my work. Boy, there can be a lot of value from something like that. We're at least a relatively litigious society, a lot of lawsuits. And again, some of them are legitimate, some of them are a little frivolous. So even for people who aren't in those sort of higher liability professions, lawsuits happen. Slipping and falling on some recreational property, or getting in a boating accident, or you name it. Many of you who are on here probably have either personal experience or people who've been involved in that kind of stuff. And so again, being able to pass on an inheritance that has a strong level of protection from being gobbled up by that sort of bad circumstance that, again, might not be of your child's making. They might just be in a bad spot. A lot of people find value in that. So then also another type of liability that can come up is, just bad health circumstances. Your child might be perfectly fine right now, but by the time you pass away, or maybe in some subsequent years, that child's health deteriorates. And so then they might be facing significant healthcare costs that could eat up the majority of what they've earned and accumulated for themselves. The most common example of this is when people are facing long-term care, because very few people end up can afford or end up investing in long-term care insurance. It's always a good option to take a look at, but some people who look at it say, boy, I can't afford those kinds of premiums. And so that means if somebody transitions into a long-term care facility, that kind of care isn't covered under Medicare or regular health insurance. And that means they're going to be paying for it out of pocket until their assets are low enough where they might put in an application for a means-based program. And a couple of popular means-based programs are for veterans, this thing called an improved pension program through the Department of Veterans Affairs, and for everybody else, or some veterans where that improved pension program is not a good fit, through the Medicaid program. And again, those are means-based programs, and a lot of people, unless they do some specific long-term care planning through their estate plan, the assets that they have often need to get spent down, or some kind of planning needs to be done in order for them to then be qualified to get assistance in paying for care. Well, the reason that's important is you can set up an inheritance to that loved one where it's then not a countable asset, meaning it's not an asset that would need to get spent down for them to be able to receive eligibility for assistance in paying for care. And because the ages of inheritance have, gone up significantly because life expectancies have gone up quite a bit. People are living longer. So what's the situation of your child or whoever this loved one is by the time you pass away? If you pass away in your 90s, your child might be in their 60s or 70s and maybe not that far from long-term care. And so having that inheritance kind of prepackaged in such a way that, if they were to go into a nursing home, the assets that they inherit from you wouldn't be considered countable assets that just need to get spent down. And instead, those funds can be used to make sure that they maintain a good quality of life and can afford the different things that assistance programs won't pay for. Somebody who's in a nursing home might be getting help in paying for their care, but that help doesn't pay for everything that somebody might need. It's not going to pay for a haircut or a new sweater or some new bedding or just a TV, just anything that the person might be able to use to make sure that they still live a good life. And so because of the statistically many people transfer into long-term care facilities for at least some period of time before they pass away, making sure that after you pass away and you pass assets onto those people, that they have some options and some protections can make all the difference in the world. So even if they're not sick right now, there's nothing that says that they couldn't get in a car accident, the day after you die, or get a dementia diagnosis where they maybe are going to need care for a really long period of time. So those are some of the most common things when we're talking about protecting against bad circumstances. So, divorces, creditors, lawsuits, bankruptcy can be another one. I had a client some number of years ago where mom had grown up in the Depression, and she was very excited because she'd been clipping coupons her whole life and had accumulated a nice little nest egg, and she was going to be the first one from her family to ever be able to leave an inheritance to her kids. And so it wasn't a gigantic estate or anything, and I think it was between about $600,000 and $650,000. And so she'd done an estate plan, and she because she was the first one to ever be able to do this. She wanted to just make absolutely certain that her kids were protected in any manner possible, so that they actually got the use of these funds. And her 4 kids were all in their 50s and 60s, all very responsible people. They'd worked their whole lives. No big health concerns or anything at the time mom was doing her estate plan. But she was still, it was a big priority for her to make sure that, this money passed on and was able to do good things for the family. So unfortunately, quite literally the month mom had died, or the month before mom had died, I should say, one of the 4 kids had filed for bankruptcy. And the reason for the bankruptcy was that his spouse had gotten very sick and they'd rung up a very large amount of medical debt. And so, spouse couldn't work anymore. He was struggling to, both care for his spouse in the manner she needed and keep working and everything. And, medical debt is the number one reason for bankruptcy in America. And so he had just filed for bankruptcy. Mom passed away. Well, when you file for bankruptcy, you have to disclose any kind of inheritance or interests in property that you might be receiving. Well, so mom had done a trust, and we were going to start administering the trust, but needed to provide a copy to the bankruptcy court. And so they had to go through it. And ultimately, the judgment was, yeah, this isn't subject to the bankruptcy creditors because of the terms of the inheritance that are created here. So the money gets to stay with son, which, it was $150,000, $160,000. We're not talking millions or anything. But that was a huge deal for him because, he was about 60. He's wondering if he's ever going to be able to retire because of just a string of bad luck in terms of his spouse's health. And so making sure that the money that came from mom was there to be able to support him, it created a nice safety net for him. So it wasn't because he was irresponsible or that, he wasn't a hard worker or anything that put him in those circumstances. But again, thankfully, mom just wanted to be very conservative about it. And, hey, anything I can do to protect the kids, well, that turned into a $150,000 good decision. So it's because life is unpredictable and none of us have crystal balls. Some people will take extra steps in their estate plan to make sure that the assets that they're passing, benefit these loved ones, regardless of the circumstances that those loved ones might find themselves in. Which brings up another scenario, which from this example, I've sort of mentioned it, but it's not just your child's health or liabilities. Generally speaking, when they're spouses, your child's on the hook for things for that spouse as well. And the big one can be long-term care. And you can, again, protect funds from those long-term care expenses, or if the spouse has a diagnosis or an issue. If you're not leaving funds to children, maybe you're leaving it to friends or siblings, you also have to think realistically about what's their situation going to be at the time you die. If you're in your 60s and you're thinking about doing your estate planning and you might be leaving something to your brother or sister, well, they're probably around the same age you are. So by the time you pass away, what's their likely health going to be like? So one example that I had to deal with a couple of years ago for that was my client had dementia, and he was in an assisted living facility. It cost about $7,000 a month. And his brother passed away. His brother didn't have any kids. He died out west. Had about $1 million estate, and my client was about a 15% beneficiary. So, coincidentally, from my other example, there's another person who's inheriting about $150,000. But unfortunately, brother who died out west, his estate plan wasn't what I would consider real great. And it didn't have any provisions around the health or circumstances of my client, the brother who was in an assisted living facility and rapidly going through all of his own assets. So because of a lack of provisions, there wasn't any choice but my client just receiving $150,000 outright. And then he had some options to do a little bit of planning, but not nearly as strong or as robust as if brother who was out west, if he'd have just put certain provisions in there, my client, the brother with dementia, could have gotten all $150,000. It could have been supplementing his life and not just getting eaten up at $7,000 a month until it was all gone. So, those are the sorts of things that I'm sure when the brother who passed away was doing his plan, he wasn't thinking about, well, what if my brother is getting $150,000 from me, is sick, or because hey, he's perfectly fine right now. Circumstances change, and in my opinion, that was a $150,000 mistake not having those types of provisions in there. Because again, there's no crystal balls. We don't know what the future holds for anybody. And so, you don't put these provisions in there because you hope something bad happens to somebody. You, of course, care about this person enough where you're leaving them money. You hope for the best for them. But this is what brings us to kind of hope for the best, plan for the worst. And, a little bit of planning in advance of a situation can go a long way towards making sure that the person's well provided for and that the money, again, is doing for them what you hope it does. Another sort of circumstance can be, if a spouse ends up needing care. And a lot of people don't realize that for things like inheritances, it doesn't matter where the money came from or whose name it's in. If somebody's in a nursing home, so as an example, let's say you have a son and he's married and his wife ends up needing care. His inheritance, if it's just sitting in his name or in both of their names, either one, is on the hook to pay for that care cost. If you don't have other provisions in your estate plan that can do things like, oh, well, we're going to hold this money in trust for my son and support him with it, but then have it not be a countable asset. If that other spouse, his wife, needs to get assistance in paying for care, we're not going to subject the inheritance to that expense. So just many, many different types of circumstances that can come up that, again, people aren't hoping for, but, can just rear their ugly heads. So that's the major things that you can help protect your loved ones from these types of bad circumstances, these creditors, bankruptcies, divorce, lawsuits, later in life nursing home costs, in a manner that, your child can, invest their funds and use them as they need to. But again, the purpose of this isn't trying to maybe control them from beyond the grave. You want to control people from beyond the grave if you don't trust them and you're worried that you need to protect them from themselves, which is a class that's coming up very soon. But if you absolutely trust somebody, you don't need to tie their hands. You just want to kind of be able to put up a gate so that the barbarians of bad circumstance can't come in and pillage their inheritance. So very strong protections that can be created. Nothing's absolutely bulletproof, but there's very, very strong protections that would be very difficult to pierce. And that's probably one of the most popular options in all of estate planning. And I can't tell you how many people I walk through that stuff with who tell me, boy, why doesn't everybody just do this? And, my response to that is, well, did you know you had these options before we talked? Well, no, I didn't. So, that's kind of the value of you guys tuning into classes like this. You get a good sense of, what your options are. A lot of people think an estate plan is just naming who gets what and who's in charge of things and it's done. And it's not. It's much more robust. Lots of what if planning and tax planning and different things like that can be incorporated into somebody's estate plan. Our perception of this is always that this is everything our client ever accumulated in their life. So we want to treat it with some extra care and again, hope for the best and plan for the worst. So I'm pretty much out of time. I wanted to allocate a couple of minutes in case there's any questions. There's a Q&A box in the Zoom link here. So if anybody has any questions, you can just type them in there and I'm happy to address them. In addition, there's a evaluation that everybody should have received. And it'd be wonderful if you'd fill that stuff out. If there's anything that we talked about here that, the moderator, our technical person just pointed out to me that you don't have the evaluation yet. It comes out right after the webinar is over. So you guys will receive an evaluation. We go through that stuff to get a good sense of whether or not the information and topic was useful to people, and that it was understandable. So, please fill that out. If there's anything that we talk about here that you think really pertains to you, and information's great, but what's even better is if you actually do something to improve your situation with that information. So if there's anything that anybody wants to follow up regarding this kind of topic, you have an ability also to request an initial meeting with myself or one of the other 5 lawyers at our office. Again, we don't do any area of law other than this. So any of the 6 of us, would be competent to run through all this sort of stuff with you and see if there's a good fit for your circumstances. So we don't charge for our initial consultations if anybody's interested in talking directly to an attorney about this type of topic. Also, for each of you, this was a taste of one of the options in estate planning. We actually have an in-person class coming up at the Oshkosh Riverside Campus, Fox Valley Tech. And that's actually October 13th. And there's 2 different classes, one at 2 and one at 6. Those are free classes. And one of the attorneys will be running through both a little bit on the topic we covered today, but also many, many other topics, things like powers of attorney, for finances and healthcare, wills and how those work, trusts and how those work, and then quite a bit on long-term care planning, different options people have if they're concerned about maybe protecting themselves against their own long-term care costs. So that's just a brief overview of what you can expect to hear if you attend that class. So again, it's referred to as our wills versus trust class, and it's sort of a survey class. It's Oshkosh Riverside Campus, October 13th, 2 and 6. If you are interested in that one, you can either go to OshkoshEstatePlanning.com to sign up for it, or if you call our office, we can get you signed up. It's 920-993-0990. And in part, I'm just killing a little time to see if any questions come in here. Or whether maybe I explained everything perfectly and you understand it all. Nicole, have we received any questions?
No questions.
No question. Okay. Well then, I guess I did a perfect job and everybody understood everything I said. So really appreciate your time. If you want to follow up with one of the attorneys, you know how to get a hold of us. Otherwise, we have that class that's a little bit more in depth on this and many other topics on October 13th. So, would hope to maybe see you at one of our classes. And again, as always, we're going to be teaching another one of these webinars next Wednesday at noon. So appreciate everybody's time. I hope you found this useful information. Now go out and use it for something good for your family. So take care and have a great afternoon.